A pleasure to have you on the program this afternoon, Robyn. Can you firstly share some insights into how the proposed amendments in the Electoral Matters Amendment Bill may impact the inclusion of independent candidates in the electoral system?
Absolutely. Good afternoon, and thank you for having me on the show. So what we see now is the Electoral Matters Amendment Bill. And yesterday was the closing date for submissions on this particular bill, written submissions that is. And this was a necessary bill that needed to come through. So we had the Electoral Amendment Act that was passed last year, and because of this, there needed to be some technical amendments made to connected pieces of legislation that also talk to elections, candidates, and in this case, independents now. And one of those connected pieces of legislation is, as you mentioned, the Political Party Funding Act. And on that point, this particular bill does have some, I think, significant and far-reaching consequences for, as you mentioned, secrecy and transparency around the funding of independents. Insofar as it affects the Electoral Act, the amendments proposed by this bill are relatively minor and they are legally required. So we have no fundamental issue with that inclusion on that particular part of the bill. A lot of our issues do stem with the consequential amendments that will affect the Political Party Funding Act.
Remind us again when you made your submissions.
I'm so sorry, could you repeat that?
Okay, basically I was asking when exactly did you make these submissions?
So we made these submissions yesterday. The closing date for the submissions for the Electoral Matters Amendment Bill was yesterday at 4 o'clock. So this was tabled, discussed last year in a meeting on the 7th of December for the Portfolio Committee who's dealing with this, Portfolio Committee on Home Affairs. And a week later they introduced the opening of written submissions, and the closing date was yesterday.
It's quite intriguing that some proposed amendments in the bill are also linked to political party funding, the act that is. Can you elaborate on how these amendments might lead to increased secrecy in political party funding and potentially benefit established parties?
Absolutely. So there are two key issues with the amendment that are going to affect precisely that, the sort of secrecy and transparency around funding. So obviously we have this act, the Party Funding Act, which just speaks to political parties, and now it will have to speak to independents. But there is a significant amendment that's coming through here. So the President has always had the powers upon a resolution from the National Assembly to create regulations to the law. However, that particular part has now been amended, where it seems as though the President's powers to do that has been expanded with a smaller parliamentary oversight and inclusion of things that the President may, after taking these resolutions, consult with committees. It is unclear what these committees will do, how they will act as a check and balance on the President's powers. And it's also including things that the President can take into account to change the limits in the Act. So currently you disclose if you receive a donation of 100,000 Rand or more, and your limit is capped at 15 million Rand. With this particular amendment that I'm mentioning, the President can take into account inflation, the President can take into account what parties or independents say is the cost of running their party and elections, and then increase that disclosure threshold to some higher number, perhaps, and that 15 million limit as well. So what this creates is an opportunity for parties and independents to become more heavily reliant on private sources, and it also raises the secrecy level because now the public will not be able to see this disclosure any longer. So that's the one. And on the other hand, the Act is also changing the allocation formula for public funds, which I think is going to work heavily in the favor of larger established parties.
I want us to crystallize some of the points you make. Clause 26 of the bill appears to give greater power to the President regarding political party funding thresholds. How do you perceive this amendment's potential impact on the private sector influence in South African politics? It is a subject that's often talked about.
Absolutely. The exact amendment that you mentioned is what I was talking about with the president's expansion of powers to create regulations that will increase these limits. And what we are going to see, perhaps, if the president increases this, is this greater level of secrecy. So I, for example, in this particularly important year of elections, am not going to be able to vet who is backing my political party or independent in large numbers. And that's always our concern, is having private interests, the ability to donate in such large numbers, and that not being made available to the public. So we are not able to act as that check and balance mechanism where we can hold our representatives to account for the kind of money that they are receiving. So this clause that you were talking about, I think, is definitely going to increase an element of secrecy by allowing political parties and independents to accept larger and larger amounts of funding, and that not being disclosed to the public.
In extension to this, the suggested changes in Clause 29 regarding the allocation formula for the PPFA funds seems quite significant as well. Can you explain the implications of shifting from 66.6% to 90% proportionally in allocation, and how might it affect smaller parties?
Absolutely. So there are two funds that are administered under the Party Funding Act. You have the Multi-Party Democracy Fund, which is a fund that anybody can put money into, and it's distributed to represented parties and soon to be represented independents. And the other fund is called the Represented Political Parties Fund, will also include independents, and this is public money, in other words, taxpayer money. So how this is currently distributed is 2/3 on a proportional basis, in other words, in accordance with whatever amount of seats you hold, and 1/3 equitably. So if you take that 2/3, that means 66%, so just more than half of the money is proportional, and the remaining 30 or so percent equitably. Well, what the Act is now saying is actually that 2/3 is going to equal 90%. So in other words, most of the money, almost all of the money in those two funds are going to go to the proportional seats allocation of parties. So if I'm a big party, like the ANC, if I hold most of the seats, it means I'm going to get most of the money. And if I'm a smaller party who holds only a few seats, even one seat, it means that my money is going to be drastically reduced, or to the point where I may not receive any significant amounts at all. So it's going to be larger parties that are essentially going to get the lion's share of money.
Robyn, in your analysis of the bill, you mentioned potential conflicts of interest with the president having power over party funding. How do you see this dynamic impacting the balance between party leadership and also as head of state?
I mean, it's an absolutely biased relationship, and this is really the crux of our issue with this. So we have spoken about the president having powers to amend regulations and possibly increase the limits for disclosure, which are the backbone of the Party Funding Act. This is what gives us transparency. But any person who is going to be the president of our country is also more than likely going to be the president of his or her party. So which means when you inhabit this role of president, you are acting both in the interest of the state, but also in the interest of your political party. And these two things are conflicting stances. There's a lot of power vested in you, and you can amend, in the case of the PPFA, legislation that could actually work to the advantage of your political party, not to the advantage of the people at large, where your position as president of the entire country would ask you to do. So this is an issue that we have where your interests may be divided, your loyalty may be divided between party and state.
And as we wrap up our conversation, and on the part of your organization as well, can you highlight any specific strategies that My Vote Count is employing to really advocate for a more equitable distribution of funds and also increase transparency in the political and electoral process amidst these proposed amendments?
Well, I think our clear action is, first of all, making a submission. As I mentioned, we made one yesterday, and you can see that submission on our website. This is one of the clearest ways in which we can intervene in this process. We have also requested to make oral submissions on this matter as well. And we also have our court case, which we launched last year in May, and our founding affidavit in that court case spoke specifically around the potential for increased transparency and secrecy and the constitutional inconsistencies that the PPFA has in making those things clear. So these are two very big things that we are currently doing to address the issues that we have raised here today.
A big thank you to our guest, that's Robyn Pasensie, for providing valuable insights into these intricacies of the Electoral Matters Amendment Bill and also the potential implications for South Africa's electoral system.